Good morning. I'd like to call the meeting to order. I'm Nancy Corrigan. I'm the chair of the Enforcement Program Oversight Committee of the California Board of Accountancy. Today is Thursday, January 17th, 2019. We're meeting at the California Board of Accountancy boardroom in Sacramento. I would like to start by taking the roll, and I would like the first member of the committee on my right to start, please, by stating your name.
Michael Savoy.
Nancy Corrigan.
Mark Silverman.
Alicia Burhow.
Dan Jacobson.
Carrie Ann Farrell Hines.
Great, so we have a quorum. Thank you so much. The first item of business is the approval of the minutes of the March 22nd, 2018 meeting of the Enforcement Program Oversight Committee. And do I have a motion to approve those minutes? Motion to approve. And a second. And is there any further discussion by the members of the committee? Is there any discussion from the public? There being none, Ms. Reed, may we call for the vote?
Alicia Burhow,
Yes.
Nancy Corrigan,
Abstain?
Carrie Ann Farrell Hines.
Yes.
Dan Jacobson,
Abstain.
Michael Savoy.
Yes.
And Mark Silverman.
Yes.
So given that vote, the motion carries. I'd like to proceed to the second item on the agenda. That's a discussion and possible action regarding proposed changes to Title 16, California Code of Regulations, Section 98, Disciplinary Guidelines and Moral Orders, Section 99, Substantial Relationship Criteria in Section 99.1, Rehabilitation Criteria for denials, suspension, revocations, restorations, reductions of penalty. Mr. Franzella.
Thank you and good morning. So the purpose of this agenda item is to present to the CBA for its consideration proposed modifications to, again, the disciplinary guidelines, and the regulation concerning the disciplinary guidelines that incorporates it by reference, which is CBA Regulation Section 98, also CBA Regulation Section 99 on substantial relationship criteria, and CBA Regulations Section 99.1 rehabilitation criteria. The CBA is being asked to approve the proposed revisions to the guidelines and the associated regulations for a future rulemaking, including any edits or additional feedback as members may have. So the CBA last considered the disciplinary guidelines and rehabilitation criteria in 2017, and staff have been working with DCA on completing the necessary materials to initiate that rulemaking. However, as members may recall, during the last legislative year, the legislature passed Assembly Bill 2138, which has resulted in additional amendments being necessary to the board's guidelines and substantial relationship criteria and rehabilitation criteria. And so we're taking this opportunity prior to finalizing the rulemaking materials. Staff are seeking to incorporate the necessary changes to implement AB 2138. So all the changes originally adopted by the CBA as part of its review in 2017 are noted in single, underline, and strike through. And to provide a bit of background on the nature of those changes that the board considered in 2016 and continuing into 17, for those members who weren't on the CBA during the previous discussions, the changes focused on the following areas: revisions to what are Section 5 of the guidelines and CBA Regulation 99.1 related to rehabilitation criteria. We added a new section, or the board added a new section on rehabilitation evidence. The board added a model related to permanent restricted practice as a result of legislation that passed in 2016. There was revisions to the model orders related to reinstatement of a revoked license, and there were revisions to various optional terms and conditions designed to align with the board's disciplinary orders, and just general revisions to improve readability, clarity, formatting, and the like. For the item before you today, all the changes resulting from AB 2138, as well as staff's recent review of the guidelines and the substantial relationship criteria and rehabilitation criteria, are noted in double underline and strike through. And the paper, or the agenda item itself, is broken up into a couple of sections. The first dealing with substantial relationship. It has rehabilitation, additional changes and next steps. My plan today is to just cover each of those sections individually. I'll turn it back over to the chair, and happy to answer any questions members may have, so we can just take each section individually. So the first changes I would like to highlight relate to the substantial relationship criteria and CBA regulations, section 99. And these can be found in attachment 3 to your materials. So the changes being brought as a result of AB 2138 require the CBA to add to its regulations 3 new criteria, specifically the nature and gravity of the offense, the number of years elapsed since the date of the offense, and the nature and the duties of the profession which the applicant seeks licensure or in which the licensee is licensed. And these particular changes can be found in attachment 3 and specifically in subdivision A. In addition to the required changes for AB 2138, staff are proposing an additional change to the criteria. And in attachment 3, this can be found in subdivisions A5 and B4. Specifically adding crimes and conduct that reflect a lack of sound professional or personal judgment relevant to the practice of accountancy, regardless of whether harm has occurred to a consumer. And we're putting that forth for the board to consider as adding to its substantial relationship criteria. This is consistent with how courts have evaluated crimes and substantial relationship over the years, as well as providing increased transparency to individuals who are either applicants or licensees going through the disciplinary process, so they can understand the board's, further understand the board's substantial relationship criteria. So with that, on the substantial relationship, I'll turn it back over to Ms. Corrigan, and I'm happy to answer any questions members may have.
Are there any questions for Mr. Franzella? Yes.
So, first of all, on line 4 of 16 CCR, California Code Regulations 99, the proposed one. I just a typo. I think there's supposed to be of before professional conduct.
Yes, there are, yes.
Thank you. Secondly, 99A, the proposal currently reads criteria for determining whether a crime is substantially and so forth, to match the paragraph above. Shouldn't it read a crime or act of professional conduct?
So A and B are different. A deals with the crime, subdivision B deals with the acts of professional misconduct. The new criteria only applies to the crime, these, so.
Thank you. And in the, I'm also on section 99, but on B4 reads, conduct reflects a lack of sound professional and personal judgment, as you just mentioned. Where in AB 2138 or in current law is there a suggestion that personal judgment should be in that?
We're bringing forth that to the board for consideration. It's not this is the one area of the substantial relationship criteria that's different than AB 2138, so we're bringing it forth to the board for its consideration. It grew primarily from going up a bit to A5, where there's offenses, and we're going to change that to whether the crime reflects a lack of sound professional judgment, and it actually should say professional or personal judgment in that as well. And so it's the same for both the crime as well as the professional misconduct, so we're trying to mirror those. It's similar to how the courts have looked at crimes in the past to determine whether or not they don't distinguish between simply the professional. They also look at whether there's sound professional or personal judgment in what they were doing. So we're just bringing that forth for consideration for members to consider adding to the guidelines.
I haven't seen any cases that talk about personal judgment. Do you have any citations or anything like that?
We do. I didn't include them in the paper. They were included in prior reviews of substantial relationship criteria the board has had in the past. I just don't have the citations offhand. I'm happy to provide them in the future.
Thank you. And lastly, so the new and operative on July 1, section 480 of the Business and Professions Code says that the board can deny licensure on the grounds that the applicant was convicted of a financial crime currently classified as a felony that is directly and adversely related to the practice of accountancy. I note that there's a discussion on page 5 of the purple documentation that we got, but there's no inclusion of that language anywhere. Am I correct in that
You're
assessment?
correct. We haven't, I guess jumping to that next step section to answer your question, we had requested the DCA can kind of convene the affected boards. There's 6 boards or bureaus who were affected by this additional carve-out for the financial crimes that are felonies that are directly related. And so that meeting was Monday. So we're waiting. We received some initial model language or some thoughts on that. We had some pretty good discussions. Staff only received it that, I want to say it was either Friday evening or Monday morning. So we're just assessing it right now, and it's something we plan to bring in March, knowing that we would have another bite at the whole regulatory package at that particular time.
And my understanding is that March is kind of our goal for passing or taking a pass on this stuff.
Yes, in the sense of trying to make, be in line with what DCA's calendar is. They're trying to balance probably what they believe are anywhere to, I want to say 50 rulemaking packages that they're anticipating. And so they put forth a calendar last year that Ms. Bowers and I looked at. So, and that also gives us the around 18 to 20 months that we need to do the regulatory process to
Thank
make
you.
July 1, 2020.
Thank you.
Yeah.
Thank you.
Are there any other questions for Mr. Franzella at this point in his presentation? If not, go ahead and continue, please.
Thank you. So moving on to rehabilitation criteria, this can be found both in attachment 4 in CBA regulations, section 99.1, as well as in attachment 1 in the guidelines in section 5. For ease of following along, though, I'm just going to use attachment 4. It's the same language. AB 2138 requires that DCA boards consider whether an applicant or licensee has made a showing of rehabilitation if either of the following are met. The applicant or licensee has completed the criminal sentence at issue without violation of probation or parole or probation, and a board applying its criteria for rehabilitation finds that the applicant is rehabilitated. So while the CBA's existing rehabilitation criteria includes a reference to successful completion of criminal sentence, to ensure conformity with AB 2138, staff have incorporated the exact text from AB 2138. And the revised text in attachment 4 that implements 2138 can be found in the various enumerations of item 3, 4, 10, 11, 14, and 15. And similar to what we did primarily for substantial relationship criteria, we're not doing anything above and beyond taking the language that the bill required and inserting it into the law or inserting it into the regulations. We haven't really reformatted the rehabilitation criteria, just simply inserting it in to make sure that we can comply with 2138. So with that, turn it back over to members and happy to answer any questions on the rehabilitation criteria.
Any questions at this point? Thank you.
The last set of changes we have, staff took the opportunity, obviously, since we were in the disciplinary guidelines, to take a look if there was any other items that the board may wish to consider for additional changes. And staff are proposing the following additional changes to the guidelines. we would like the board to consider adding both ethics CE and regulatory review, the regulatory review course to a list of standard conditions for probation. As members will note, most of, I want to say, every disciplinary matter we bring before the board generally includes ethics and regulatory review. So it is by default almost turned into a standard term and condition. So this will just put it in place, and so the ALJs will recognize that as well. And staff are also suggesting that the board make, when instituting peer review as a standard term, or as a peer review as a term and condition of probation, that it be paired with samples of audits, reviews, and compilations where staff can request the documents or a listing of the audits, reviews, or compilations that they performed, and then select those for us to review as well. Staff did notice, and others have brought to our attention, that on the regulatory review and the ethics, we didn't cross them out everywhere and make all the necessary changes, so we have identified some of those, and we'll, when we bring it back in March, we'll make sure to have captured all of those. So with that, I'll turn it back over to members, and happy to answer any questions you may have.
Are there any questions for Mr. Franzella? Are there any questions from the public? And that completes your presentation?
I was just going to highlight the
Okay.
next steps.
Okay, go ahead. Yeah.
And so,
Going further?
again, to meet the July 1, 2020 implementation, DCA has requested that the boards and bureaus turn over their, or submit their rulemaking packages by May 1st. For the board to meet this target then, it would be at the March 2019 meeting, the board would need to take action to initiate the rulemaking process. DCA has been in developing model regulatory language for some of the criteria we have today. We received that, I want to say Friday evening. I looked at it Monday evening after a meeting we had with DCA, so we're digesting that right now to determine whether or not we need to offer any additional edits or thoughts for members' consideration, and we'll bring that back in March. And as I pointed out earlier, there was also the financial crimes directly and adversely. That model language was discussed at a meeting with DCA on Monday. Staff are evaluating that, and will bring forth a proposal for the board's consideration at the March meeting. But bearing in mind, we're also concurrently working with the legislature to make, to consider a legislative proposal to modify the financial crimes to make it, instead of directly and adversely, substantially related, and remove the term fiduciary from that language. So we're kind of working on dual paths until the legislation is considered and either put into place, or we're unsuccessful and we're going through the regulatory process. So for the March meeting, staff will provide all that information from DCA that we've received. So staff recommend the CBA approve the proposed changes to the guidelines and CBA regulations for sections 98, 99, and 99.1 for future rulemaking. And with that, I would turn it back over to the chair and answer any final questions members may
Okay.
have.
Any final questions for Mr. Franzella from members or any from the public? And given that we have these recent changes that you're digesting, are you asking us to take action today on what you've presented thus far, or are we waiting until the March meeting?
We're asking that there's action taken just so we, but I assume at this point it could still just be direction from the committee and the board as a whole, that they're supportive of the changes we've put in place, and that to incorporate any necessary changes for board's consideration as a result of its review of DCA. So an action probably is not necessary, but
Yeah.
direction would be
Is
nice.
that-
Burhow?
Yes, that was my question is if, not that we expect any additional changes, but if, I'm a little concerned about taking action today, if there's going to be possibly additional changes, and then getting
Absolutely.
additional information from the other boards that are also dealing with this.
Absolutely.
Yeah.
So I think the consensus of the committee is probably just to encourage, give you that direction, to continue with the process, and then we'll have a more refined product
Right.
at the March meeting. Does that make sense?
Yeah,
committee?
and I'd be really interested in hearing if there's any additional feedback from the other boards that are dealing with this as
Yes.
well. So,
Yes.
and seeing if that anything needs to be incorporated into our document.
Absolutely, yes. Okay,
And,
yes.
Dominic, would you be able to provide those citations about personal judgment via email to me, say by the 20th of February?
Yeah, I'll provide them to all members. I don't have an issue.
Perfect.
Yeah.
Thank you very
We
much.
can look at it.
Yeah, we all
including-
want to know.
Yes,
We
that,
all wanna know.
yes, thank you, thank you. Okay, anything else for Mr. Franzella while we have him at the table? Okay, if not, moving along, are there any comments from the public at all? Okay, next agenda item 4, agenda items for the next meeting. Well, we know one of them will be what we just spoke about.
this.
Sure.
That's
So
helpful.
that's a given, that's an easy one. Any others? Okay. Hearing none, then I adjourn the meeting.
Thanks.
Thank you.